going to talk to you about the forms, and then also a little bit about a small little hearing that you will participate in, because there has to be a court record of this proceeding. Years ago, when I first started in the court system, this was almost a rubber stamp. In other words, the parents petitioned, the child didn't really understand what the nature or the consequences of this application meant. And then all of a sudden, the court signed a decree. And things have changed quite a bit. There are so many advocacy groups, so many levels of disability, that we really become cognitive of that, you know what, these individuals who may have a level of disability are such, it's very important to us. And we don't want to just make the decision based upon some papers that we receive. But the most important thing is that every case is separate, and it's a case by case, so we want to make sure that, you know, the individual that the judge is appointing is going to be responsible for their ward, and that ward, unfortunately, won't be able to make decisions during their life once you conclude the guardianship application. So we want to really make sure that we vet out medical reports and all the other documents that you're going to be asked to submit before the judge makes a final decision. Maybe your child is in high school and they have hopes, they're high functioning, and they have hopes of going to college. Maybe this guardianship wouldn't be the appropriate and we'll let you know that. If you come to us with a question in mind, we'll let you know. But maybe the application is something that your child unfortunately would need to assist them in the continuance of their life. So we'll make sure that the judge signs the order for the appropriate type of relief to benefit both you and your loved one. So without anything further, I am going to introduce Ms. Angela Conti, and she has a whole wealth of information as far as these forms and your application, and then I hope to see you afterwards for questions and answers. Thank you.
Good morning, everyone. My name is Angela Conti, as you just heard.
Could you speak up?
If you did not pick up a packet, they're in the back. If everybody wants to take a minute and give them a packet, you're looking for them, they're in the back on the brown table. I'll give you a second. Everybody's ready? Everybody wants the packet? You want the packet? The first thing I'm going to say to you is do not worry about remembering anything that I say to you.
It's very hard to hear you.
Okay. So the first thing I'm going to say, what I just said is do not actually worry about what I'm saying here today, because I'm sure none of you are going to remember it, like anything else. So it's kind of like talking to you. It might be insulting. I was going to say it's kind of like talking to your children, because I'm giving a lot of information at once, but I don't need to call you all children. It's just a lot of information. Okay. So I'm going to tell you right off the bat the things that you need to start with before we go to the package, okay? So you want to start when your child is about 17 years old. It's about a year-long process to get this done. It's not a year-long process that you're going to be in the courts with us. It's a year-long process because of things you need to do before you can file the application. The first thing you're going to do, and you should do that today when you go home, order a birth certificate. We're going to take a birth certificate from you, and you are not going to receive it back. So if you do not have an extra birth certificate, original. So if you do not have an extra original of the birth certificate, you're going to go on to the Department of Health, Department of Vital Records. I think it's a $15 fee. They will FedEx it to you. Order an original birth certificate, okay? That's the starting thing that you need to remember to do. The second thing you need to remember to do is deal with your doctors. I'm going to jump ahead to the doctor forms. There are 2 forms in this packet. They are the affirmation of examining physician and the affirmation of a licensed psychologist. This is part of the reason it takes about a year to get these done, because the first one is your primary care doctor. Who's going to fill out the packet for, who's going to fill out this document for you at your next application, your next visit appointment. It's not going to be a problem. The licensed psychologist is going to be a problem. But what we're told, there's about a 6 to 8 month waiting list to get your child assessed. Okay? So now the question is going to be, my child has been assessed so many times, why do I have to do this again? It has to be done within 6 months of when you're filing the documentation. Right?
What type of assessment?
A full-on psychological assessment. Okay? Go ahead.
I guess my question is that do you guys provide the psychologist?
No, we actually are not allowed to provide a psychologist to you. We cannot recommend lawyers and we cannot recommend doctors. So if you call up, you're going to get an answer that you're not happy with, that people think we're being rude. We just can't tell you. So what we advise you to do is speak to other parents who've gone through this because they can refer you to people, okay? I always refer people over, and sometimes Jackie, she'll be mad that I refer people to her, but she has a list of people. Right here, this young lady, she has a list of everything, okay? And I'm starting out with those two things, and those are the most important things that you need to do so that you can start it. All right, now I'm going to step back for a second and tell you stuff that you're probably not going to remember, but that's what I want you to remember, what I just said. Okay. The packet that we've given you, as you can see, it should have a page that's filled out on the front, so you're going to say, why am I picking this up? It's not a blank. And behind it, it's going to have an empty one. We've done samples of all the documents, so that when you sit down to look at them, you can put them side by side, and for the most part, just compare what's in there, okay? Ron alluded to, we've made videos. There's videos online that sit down, somebody actually sits down and goes through the packet and fills it out. So you can sit down in front of the TV or your computer and you can do it, and you can stop, and you can go back, and you can rewind. Which is why I'm saying don't worry too much about remembering what's in these packets or what I tell you, because we can assist you virtually doing that online with these documents, okay? Yes?
Where is that?
Yeah, the link is on a piece of paper that's in the back. If not, we can give it to you, okay?
Pardon?
There's a piece of paper in the back if they haven't all been grabbed with the link. If they're gone, we can give you, we can make more, okay? So if you call the courthouse and you say, I have a question, the first thing we're going to say to you is, did you watch the videos? Because 90% of the questions that you're going to have are in the videos, okay? Again, it's not to be rude, it's just to try to be efficient. And the videos actually will answer the 92nd and 93rd, the question ahead of you that you haven't thought about. This way, you can sit down, you can watch the videos, and you can make a list of your questions, and we're happy to help you from there. We're happy to help you originally, but the video is a little bit more concise, and it's going to tell you mostly what you need to know. It's going to talk to you about the doctors, and you have questions about exactly what type of doctors, what the forms need to be, okay? Does this make sense to everybody so far? Okay. So I'm not going to go through the forms step by step with you. I'm going to touch key points that I think you need to know. So the first thing is, who can be a guardian? Anyone over 18 can be a guardian. Okay? Can your children be your guardians or their siblings? Siblings can be guardians if they're over the age of 18, okay? Usually it's mom and dad. You can be co-guardians. Can you have 3 guardians? You can have 3 guardians if you want to do mom, dad, and a sibling. We kind of don't recommend you go above 2 guardians, however, because sometimes doctors want every guardian to sign everything. So if you have 2 or 3 people and you go somewhere, you may run into a problem if the doctors want to see everybody to sign off on something. Legally, however, 1 guardian should be able to sign the paperwork, but you can't account for what happens when you're outside of the courthouse, all right? So then that leads to the next question. Can you change your guardians? You can change your guardians at any point. It's just a new paper. You're going to come down to the court. It's a new form. It's a quick form. You don't have to go through all of this once it's done. Right? It's a new form that just you fill out, you sign. I'm going to jump back for a second. All our guardians need to be fingerprinted, so if you're ever at any point changing your guardianship, they would need to be fingerprinted. That's the main thing. And we have another form, tell me if I'm going too fast, that's known as a 1031 form. Okay, a 1031 form is a form that's in this packet. It asks you where you've lived for the last 18 years. You have to fill it out, okay, for the last 18 years. This form right here. This gets sent off to the state. This is a form to see if there's been any child abuse in your home or anybody who's applying to be the guardian, all right? So guardians need to go through this form. This is the second reason then I said this takes about a year, because once you hand this form into us, we send it off to the state. They're taking about 4 to 6 months to return it to us. We cannot do a guardianship until we have this paperwork done, all right? So what I'm saying to you is to start when you're 17, doctors, and then this form, all right? Now, if you're here and your child's already 18, or you're bordering on the age of 18, you can come down to the courthouse. In case of an emergency, we can give you temporary letters. So don't panic if you're in the need of temporary letters in this industry. So your child's going to be 18 next month and they have to have surgery. And so you need temporary letters as a guardian in an emergency situation. We have people who want to go out of the country, they just turned 18, they need a passport. We can do temporary letters. We're going to make you fill out the packet, but we can do something without having to. For emergencies, for emergency situations.
To clarify, so you're saying to submit the paperwork at 17?
You want to start the packet, you want to pull the packet out when your child turns 17. You want to submit it by the time, well, you want to submit it once you have those medicals in. Okay? Once you have the 2 medicals done, then you want to submit the paperwork.
Even if you're there before 18?
You want to be there before you're 18.
Okay.
So you want to start this packet when they're 17, meaning you want to go to your doctors, you want to get the appointments, you know, when they're 17, when they just turned 17, because it's going to take you a while to get the documentation from the doctors. Once you have the documentation from the doctors and the original birth certificate, you can then come down to us with the paperwork filled out and we can take it from you. Okay, make sense?
It is mentioned that the evaluation has to be within 6 months.
Within 6
So
months.
does the primary care doctor has to be within a certain amount of time?
Well, 6 months. And so now, the next question is probably going to be, my child just got evaluated when they was 15. Can we take that? We legally cannot take that. What we can do, a little bit workaround, is if you see the form, you bring the form to the doctor, the affidavit of licensed psychologist. If they will recertify that everything is the same from their 15-year-old evaluation, we can take that, but it needs to be recertified, redated by the doctor, re-stamped, okay? Let's stay on the doctors for a second. So most of the doctors on Staten Island who deal with the disabled population know what these forms look like because they've done them. We see the same names all the time. They do them over and over again. However, when the doctors give you back the forms, so they're going to give you an actual evaluation that you're going to attach to this, and they're going to give you this form. You have to complete these court forms. If you see somebody off island who's not familiar with us, that's fine. However, you can't just take the evaluation. You have to make sure that the court forms are completed. So don't take the evaluation from them and come in, because what's going to happen is we have to kick you back, because legally these things by statute have to be completed, okay? So that's a takeaway. And take a minute and stop and look at the form, because sometimes it would ask, for instance, their name and then their license number. Sometimes their license number is not put in there. The form's going to be kicked back to you, okay? It has to be completed, doctors. They have to sign it. Sometimes they stamp the form. It has to be a signature, right? It has to be the original form. So if you're familiar with your doctor and he emails it to you, it's not good enough. All these forms have to be the original. All right, everyone still with me? You know what that's saying? Yeah, you can type it in as long as the signatures are the original. Okay? You know I'm jumping around, but I want to hit on the points that I want you to remember. Okay, so that's the doctor. So I'm going to go back. I'm going to go back to the guardian for a second. Okay. You have to be a family member to be a guardian. You do not. It can be, usually it's family members. However, we see neighbors sometimes. We sometimes see teachers who are familiar with the kids. As long as you're happy with who the guardian's going to be, or the co-guardian, that's fine. It's okay with us. All right? Do you have to have, so if you flip through the packet, at some point it's going to ask you for your standby guardians. What is a standby guardian? If you're applying to be the guardian, that means right now you're going to be able to make decisions. You can be a guardian, you can be a co-guardian. What's a standby guardian? A standby guardian is, let's say you have a car accident. We're going to kill us off in this, but we have a car accident. You die in the car accident. Who's taking care of our child at that point? Give me 1 second, okay? So mom and dad are in the car, there's a car accident, child thankfully is not in the car. So what happens now? You want somebody who's going to step up and take care of your child in your place. That is what we refer to as a standby guardian. You can put in the form, you can do a standby, a first alternate, and a second alternate. It goes in those 3 ways. So we recommend 3 standby guardians. If you don't have them, at the very least, we recommend 1 standby guardian, because otherwise what's going to happen is going to be nobody in charge of your child, okay? OPWD will step in, but for the time being, that means nobody that you've chosen is going to make decisions for your child. All right? Everybody following me? I see a lot of like this, yes.
And the standard guardian, they still have to complete the form where
I'll get to that part of the end. You have a question, sir?
Standby guardian means it could be anybody from an organization, like let's say the social service organization.
It can be anybody that you're comfortable with, that you've told, and that knows, because they have to sign paperwork, okay? So it cannot just be, for instance, an organization itself, it has to be a person, okay? Understand? Okay, so, to go to your question. When you're filling out paperwork, you're going to fill out, the first one is the petition. This is like your general, when you go to the doctor, I mean, it looks daunting, but it's not. You sit down, your name, your address, your date of birth, where you live, where you currently live, and asks you who else is in your family, pedigree information. And when you sit down to do it, you're gonna know the answers. It's just another form that you have to sit down and do. It's another pain in the butt type of thing. But when you go through it, it's gonna ask you for the standbys that are in there. It's gonna ask you anybody else who resides in the home. So let's say grandma and grandpa reside in the home. It has to be on this documentation. We have to know about it, all right? So I'm going back to your question. Anybody over the age of 18 who is a sibling, like even if they're not going to be a standby guardian, they're going to need to sign some paperwork by law. So they need to sign, if they're going to be a standby guardian, they're going to sign 2 documents. They're going to sign the waiver and consent, which are forms that are in here. You don't have to write it, you can write it down. And they're going to sign an oath and designation. And that's so that they know, because you don't want to pick somebody that doesn't know that they're going to be a standby. It's also so that they're agreeing to say, yes, we're going to be the standby guardian, and we know this person's going to be the guardian, and she's going to make decisions in the interim. 2 forms that they're going to sign. However, let's say you have a child, who lives in Missouri, and you don't want that child to be the standby because you're going to use your child who lives in Staten Island, the other sibling. If they're over the age of 18 and they're a sibling, they still need to sign these forms. They still need to know that mom and dad are coming forward to be the guardians. Why is that? Because sometimes there's a reason that mom and dad should not be the guardians, and they want to let us know. Okay? I'm going to stop for a second again. All these forms, like I said, need to be the original forms. They all need to be notarized. Right? So don't fill out the form, but don't do the signature part unless you're at, usually like your local bank will notarize things for you. So get all the way up to the signature, and then wait, take the packet and go to the bank and sign everything there. If they're not notarized, they're going to be kicked back to you. All right? Everyone still with me? Yeah? Okay. Okay.
The question is, if you have a will that states that someone is the executor of the guardian of your child, does that not hold up?
No. Well, that will, first of all, it's your wishes. So, and any will is an individual's wishes on paper. That will would have to be probated first, and then it would have to configure into the scheme with the statute. New York State law permits on a hierarchy. So, for example, if you said, I'm just going to give you an example, which I've seen before. Let's say you or a petitioner and their spouse got separated or divorced, and the spouse's opinion or one of the spouse's opinion of the other is not really the greatest anymore. So, there's no way that this person is going to be the guardian of my child after, God forbid, I'm gone. But I have a best friend who's a girlfriend who's really been, participating in my child's life, and I would love for them to be. And you put it in your will. That's all well and good to show what your preference is, but your preference first has to be validated by being admitted to probate, and then has to fit within the confines of the statute. So I think your best bet would be, or anyone's best bet would be, to do this work now. Have it in place and have your standbys vetted out by the court prior to, God forbid, anything happens. when everything happens, then you really don't have the control that you wish you had afterwards.
But does it really, like, even not matter, I think, whether if the child is over 18 and they love their sister
Yeah,
and their
yeah,
mother
so-
died?
I think Angela's gonna go through that.
So I'm gonna tell you why the
Absolutely.
guardianship matters. I think Ron hit on it, but I'm gonna hit on it again.
Okay.
So you have legal guardianship of your children till they're 18 years old. Once they turn 18, that's it. You technically, under the law, have no control to make any decisions for them. Doesn't matter on their status, if they're disability, if they're disabled or not disabled. So let's say your child trips and falls. They turn 18, 2 days later they trip and fall, and you go to the emergency room. They need stitches. And you have a child who says, I don't want stitches. You don't have guardianship. You're going to be arguing with the doctor, well, he clearly needs stitches, look at his face. But if the child's saying no, you have no legal status at that point, so what's going to happen? They're probably going to send you home with no stitches. Okay, so that's what happens. So that's what this guardianship does. It looks at it says, listen, doctor, or whoever else is out there. Even though my child's over the age of 18, I legally can make decisions for them. Okay, that's what the guardianship does.
So did you walk around with a card?
You're going to walk around with we recommend if you get it, you keep a picture of it on your phone. It's paper, it's a legal piece of paper that you're going to get that's going to have a court seal and a stamp. What we recommend people do once they get it is keep it in their car and keep a copy of it on your phone this way, because you need it always when you're in an emergency situation, right? So you want to have it someplace that you're handy. Keep a copy in your purse, that's what we recommend. If it's business hours on a Monday through Friday, you can call the court, which we do have happen. But if it's in the evening or the weekends, of course, everything always happens at inconvenient times. We cannot help you because there's nobody there answering the phone. So that's the distinction. That's what the guardianship does for you, that you can no longer do when your child turns 18. Now, sometimes we have people come in, their kids are 30, 31. They've just never had an accident. They've been going to the same pediatrician who's been treating them. What happens? The pediatrician retires or something like that, and that's how they end up with us. And they say, well, this new doctor now, he's not letting me in the room, but I've been in the room for 30 years. I don't know what's going on. Because now the new doctor doesn't know you, and he's following the law. I'm not looking to pick on any doctors for not following. I'm just saying, here's the distinction of what you can and cannot do. Make sense now? Okay. So I'm going to step back even further. Guardianship. There are multiple types of guardianship in the courts. This guardianship is known as a 17A guardianship. This is the most restrictive guardianship that you can have. This particular type of guardianship, the way it is currently crafted under the law, says that you can make every single decision for your child. Okay? What they wear, what school they go to, if they leave the house, what doctors they go to. It takes away all individual rights from your child. And having said that, the court takes it very seriously because you are taking away every single right from somebody, all right? So we do vet them pretty seriously. Sometimes parents are happy and not happy about that because, listen, we all want what's best for our kids, right? We all want to be able to make decisions for them. However, there's a high standard that's held to before you can get this guardianship. If you have a child who's on the spectrum, but is taking the school bus, taking the city bus rather, and is able to walk around and function with monetary things, can make a doctor's appointment by themselves, you may not qualify for this type of guardianship. I'm not saying you're not going to, I'm saying you may not qualify for that. And the point of that is it's not to, this is where people will get upset with us in the court. It's not to take away your rights to make decisions for your child, it's to not take away the child as an individual's rights. So there's a big push lately, I'm sure you're all familiar with that, to reduce guardianships, obviously we're the court, so we have to follow what the law is. Having said that, if you have a child who's on the spectrum, medium on the spectrum, and you think can function on their own, can go to college, can have a job, there are other types of guardianship you can do. There's limited guardianships that can be done through Article 81. That's not done through us, that's done through Supreme Court. We can advise you on that. But there's also ways that you can get power of attorney from an attorney's office. I think LPWD might have a program also with that. But basically what you would do is you would take your child, you'd go and sit with an attorney. The attorney's going to ask them some questions. Do you understand what you're signing? Usually it's for medical and financial is what they'll do. They'll sign basically a power of attorney. Any power of attorney like you have with your elderly parents, that's what I'm talking about. So if an attorney feels that the child understands what they're signing, they'll give you a power of attorney so that you can just control those certain things while your child goes on about their life as any other, individual would without you having this restrictive guardianship. Does that make sense to everyone? Yeah? If you're not sure where your child falls in that, because what happens, I'm going to be honest with you, doctors are going to say, doctors almost always will sign off if it's your regular doctor. If you're not sure and you want to make an appointment and you just want to bring your child down to the court, you know, we can have like a little bit of a conversation with your child. We can probably give you an idea of whether or not we would pass through the child through for guardianship, all right? So now I'm going to jump ahead again. So,
As you mentioned that, so even though we're gonna say 17 and say the child is 15 now, we're trying to say.
no, so we don't recommend you, no, and I'm going to tell you, we recommend you don't start until your child's 17 because the judge does not like to give them, there are certain diagnoses that are not going to change, and it is what it is. However, there are people with autism that keep learning every day, and so the judge does not like to give them 2 to 3 years out because we've seen people come back, you know, that maybe today at 15 they can't make a decision, but at 17 years old now they're getting ready to go to college, you know, on a limited basis, but it's still out there, okay? So that is the reason that we say start when you're 17. You can turn around and file this paperwork when you're 15. It's probably going to sit there for the 2 years because the judge doesn't like to do it, okay? Does that answer the question?
Andy, which scenario would it be appropriate to consider a court-appointed guardian?
Meaning,
Like if someone an adult is maybe in a residential setting and they don't have a legal guardian, like would that be an appropriate time to, like would that be beneficial for that person?
so for instance, they live in a group home?
Yeah.
So we still do the group home. Because you have to pay, okay, so let's look at that scenario. So your child is now 22, 23, 24, 30, and wants to live in a group home, okay? We're going to hold you to the same standard, decision-wise, okay? If they can make some decision, and they can function on their own, then no, you probably don't need this. However, if the group is doing the majority of stuff for them, the group home making decisions, you still want a guardianship because now, legally, the group home doesn't have to talk to you.
On that same idea, my question is, where, do you file where the guardian, the proposed guardian lives, or where, so if I'm speaking about this, someone in a group home, and that group home they got placed in is in Queens, but I want to be the proposed guardian. Do I file in your court because I live in Staten Island, or do I have to file in Queens?
It's the residence, it's the primary residence of the of the ward, so, of the parent, yeah, but,
So in other
You can
words,
file here.
we've accepted applications where the ward lives in a home in Pennsylvania, and the parent is here, and the theory behind that is usually a child under the age of 18 can't select their residence or domicile. That's usually selected by their parent, where their parent lives, or the custodian where the child lives. So even if your child is over 18 and they're living in a residential facility in another county or another state, domicile resident vests with the natural parent, especially if they're adjudicated a person in need of, a guardian.
so the idea, so when you're thinking about the idea is that their home is truly your home. So if you're here, then you can.
Thank you. Okay, what scenario would you use limited guardianship versus power of attorney?
So, okay. I'm gonna step back for a second. So you're not gonna do either of those for you, but if you have a child who's, taking the bus every day and he's working at Stop and Shop and then he's coming home and he just needs help with his finances, for instance, he gets a paycheck and, you don't know where the paycheck's gonna go if you're not helping with them. And that's kind of like a power of attorney situation, okay?
Power of attorney is, if I went with a child was 20 years old, for example, and they were borderline, and if I had the opportunity to go to a local attorney and we sat down with the attorney like any other person, especially an elderly adult, you need power of attorney for that elderly adult in the event they go into the hospital or they become mentally incapacitated. They have to have capacity at the time you visit the attorney because they have to grant that authority to you. So if your son or daughter or loved one doesn't have the understanding, and the attorney will vet that out, various questions about society, about current events, he or she's gonna ask those questions. If they can't grant you the authority, they don't have the capacity, the mental capacity, then a power of attorney doesn't really work. So maybe you look at guardianship.
Yeah, so basically, if you get refused for a power of attorney, then probably we may or may not be the next step.
Could we assess that? Sometimes we can have a little, like Angela said, a little meeting at the court to kind of give you our opinion. But, because we don't want you going down the road, filing this application, getting the doctor's reports, and then you go before the judge or a referee and they say, and that has happened. Your child is not that bad, and there are people I work with that, sometimes they need a guardian, I think, so I'm just teasing, but, in a case like that, the judge is very cognizant of taking away, especially with all the rights groups, and that's not because of that, but, what he usually says is, when I sign this paper, an individual who's incarcerated in jail would possibly have more rights than the individual and some need it, some unfortunately are nonverbal, they can't express their ideas, they have a general understanding, but some of them desperately need a guardian, and those are the ones that we're hearing.
That's why the Supreme Court.
Well, so the other place you might want to look, if you have a child you're not sure about, so if, the other thing is called supported decision-making. Are you guys familiar with supported decision-making?
Yes.
So the supported decision-making is not run through the courts, it's not connected to the courts in any way. If you Google New York supported decision-making, you're going to come across a not-for-profit in Manhattan. And they work with parties, and they work with children who are disabled, but functioning. They're out in the world and they're functioning. And what they do is they do some of these things with you. So they basically, for what we understand, because again, it's not through them, they sit down with you and your child and they spend hours. They meet for like 8, 9, 10 hours. They really get to know you. And they come up with a contract almost. And it's like a contract between you and your child. So, you'll agree to, they can agree to decide where they're going to wear, what they're going to eat, that sort of thing. But you're going to decide who their doctors are. And it's a contract that they sign, and they do give you legal documents in form of a power of attorney. So that if you're on the fence, definitely reach out to them to put a decision in. You just Google them. I can tell you we've sent people over there after we've gotten through the hearing because they haven't been appropriate, and they said they've had very good experience with them. Again, to my understanding, it does take a couple months because, like anything else, they do spend, I think, good amounts of time getting to know you and your family and your children and coming up with these agreements.
Are they a 501c3?
I don't know.
So it's a penny.
No, I think it's a agreement, but I don't know the answer. I'm pretty sure it's a non-profit if you don't think so. So that brings me to whether or not you need an attorney to do these forms. You do not need an attorney to do these forms, okay? You can sit down, you can watch the videos, you can listen to what we're saying, you can read through this, you can come in, we can help you. However, there is money out there. There is money, and I'm going to again refer to Jackie because she can refer you to it. There's, I think, is it $3,000 or $5,000 a year?
$3,000.
$3,000 a year that you can use towards legal fees that have to do with your disabled child, okay? She can tell you where you can find this information. So if you're not comfortable doing it and you want an attorney, Jackie at the end, and she's going to tell you where you get this money from. It's kind of money that a lot of people don't know about. I ran a course somehow, and she knows about it, so I always refer people over to her to get that. So if you're not comfortable, if English is your second language and you're just not able to do the forms, certainly, seek out an attorney. When may you want an attorney? And there's 2 times when you may want an attorney. Okay, so here's a question we get all the time. I'm divorced, and in my custody agreement, I have my child. So that means Dad doesn't have to sign these forms, right? Wrong. Okay? The divorce decree will terminate custody 18, 21, 24, depending on what the decree says. However, once that's gone, you're kind of starting from blank again. So even if you're divorced, you have to sit down. If you can't communicate with Mom or Dad, you have to get the waiver signed by Mom and Dad, okay? It's not just, you cannot overlook the other parent is where I'm going with this. So if you have another parent who you absolutely cannot communicate with, you don't get along, you don't know where they are, maybe a situation where you need an attorney. There's only so much, we can help you with the forms, however, we cannot give you legal advice. So if you come in with a specific legal question, we're not going to be able to answer it for you, okay? So that's in a situation where you may need an attorney. The other situation where you may need an attorney, if you look at the form, says, do you want guardianship of the person, the property, or person and property? Okay? They're very distinct and different things. If you want guardianship of your person and not your property, it means you are not going to be allowed to make any monetary decisions for your child with the exception of Social Security, okay? Social Security does not need this. So let's say your grandma left your son or daughter and you're sitting in the bank and it's $20,000 in the bank. And you come in and you do guardianship of the person, and then you go to the bank and you say, I want to withdraw this $10,000. The bank is going to say no, because you don't have guardianship of the property. They know the difference in the forms, all right? If you're looking to get guardianship of the person and property, and there's a lot of property out there, then you may want to seek an attorney's advice. Because once you put property, again, I'm going to give you legal information, I'm going to give a tip here. Once you put legal information in your child's name, it's going to affect the benefit, once you put monetary information in your child's name, it's going to affect the benefits that they can get, okay? There's things known as supplemental needs trust. That's usually where the money needs to go so that they don't lose their state benefits. We cannot help you with that. You're going to come ask us questions legally. We cannot. You want to see an attorney. I'm not going to say you should. You want to see an attorney if you're doing anything with finances. Yeah.
If someone already went through guardianship through your court and was appointed it, but they had marked person, and then they realized after the fact they made a mistake, does it mean you start from the beginning, what you just described, new psychological?
No, you can, so all the orders that you're going to get from us, all the original orders can always be amended and modified. And basically, we have forms to do most of that stuff. You never jump back and start from the beginning. Once you have guardianship, you have guardianship. So, you know, if your mom, let's say your grandma passes away and you know she's left money to your child, before you accept that money, you want to talk to an attorney. That's the first thing you want to do. But they're going to tell you need to come back and modify your order for guardianship of person and property. You're not going to start from the beginning, meaning you don't have to do the doctor's reports all over again. Okay? You're not going to have to do the 3909, which is the form we sent away to the state registry. It's just going to be paperwork at that point.
And is Medicaid covered under, dealing with Medicaid, is that covered under the one that says person or the one that says person and property?
Medicaid and Social Security usually will work with you without you needing anything from us. We've had a couple of instances where they've been unwilling to. I don't know why. It's usually like an anomaly that somebody comes in and says Social Security won't talk to me. At that point, we usually will do a limited order without guardianship of the property, saying this person is guardian, and then they can take care of the Social Security property. Because usually the money is so limited that you need it for day-to-day expenses, and we try not to involve ourselves in that. So usually no is the answer. I can't definitively say no because we have had people come back and say that they're not working with me. You know, they get the wrong person, basically. Yeah.
Usually the trigger is, if you're thinking about leaving monies to your child, or if somebody has left or is thinking about leaving monies to your child, the thing that should go up in your head is, your child is probably, you know, one of the benefits of living in the city of New York is that they got pretty good, it's unmatched. If you went to Florida or Pennsylvania, New York City has a lot of great benefits for persons who are disabled. No matter what you think of New York City, but you don't want to register money in their name, and that's why I was saying a supplemental needs trust pulls the money aside, and it allows you to still get government entitlements and supplement your child's needs with this money, utilize this money. If the money goes under your child's name and the Social Security, the government's going to see that, and they're going to say, wait a minute, I think those benefits got to stop now, and they have to use this money. So if you're thinking along those lines, whether it's today, tomorrow, and you have to create a will, you definitely want to go to an attorney and you want to inquire with them about selecting or creating a supplemental needs trust for the long-term benefits of that child.
Any questions related to that specifically? There's another form in the packet. It's called Affidavit of the Proposed Guardian. This needs to be filled out by anyone who's looking now to be the guardian, not to standby. It's going to ask you in this form, do you have any criminal history? If you have criminal history, you have to put it down. I'm going to say you have to, but put it down, because we're fingerprinting you, and we're gonna know. So what happens, things happen. Somebody might have had a DWI when they were younger, petty theft, kids steal things when you're younger, and you don't want to put it on the form, and then we get back to the report, and that's what triggers us to be like, oh, why didn't this person tell us? Maybe there's more going on than what was just not reported in here, okay? So we're gonna find out about it, just put it down. Doesn't mean that if you have a criminal history that you're not gonna be guardian of your child. It's really just gonna depend on what it is, what the thing was, okay? It's more of an impediment when, if you're asking for guardianship of a person's property and, you've been ripping off cheeks for the last 10, 12 years. And that's the situation where we're really gonna look at it. But again, life happens, we understand life happens, so it's not a now, I'm not gonna be guardian of my child anymore. So just go ahead and put it down. When you don't put it down is when it raises red flags. When you don't put it down is when we're bringing you in for supplemental hearings, when we wanna know, when we're collecting affidavits. Just write it down, okay? What else do I want to let you know?
Quick question, I'm just gonna step back. For the limited guardianship, the paperwork from the doctor is still needed if I'm allowed to take a look at it.
Yes. And that's really that's really like an emergency basis. Yeah, that we would give that. It's called a temporary guardianship. So we'll give you an order. Yeah.
It's good to have, we would always suggest you
But
submit
it's
that
definitely
because
try it out within 6 months.
Yes.
So the IEP alone is not.
I hear that.
and there are two really reports. One, it could be from two doctors, one who is well acquainted with the care and diagnosis of persons of that type of disability, or one doctor and one psychologist. So the one doctor could be the general pediatrician doctor that they've had for many years, and they're going to give a report on the nature of the disability. And the reason why we need those reports is, remember, the doctor's not going to come in and testify at the hearing. The judge is depending upon those reports or the referee to make a determination that's going to affect the child's future. So we don't take it lightly. Sometimes the doctor fills the report, and like many doctors, they check off a couple of boxes and they sign their name. The report asks for, was any diagnostic test given for you to come to this conclusion? So we are a little bit of a pain in the neck about that report. And sometimes we've sent applicants back and said, we're not a doctor, but go back to the office and say they need to complete paragraph 7, 8, and 9. Just whiz through it.
That's why I was saying, stop and read the report before you leave the doctor's office, because again, if they refer to any attachments and we don't have the attachments, we're kicking you back. If they haven't put their license number, we're kicking you back. If they haven't signed it, we're kicking you back. If they've given you the copy and it's not the original, it's going back to you. Those are basically two of the most important documents for the reason that Ron said. So I'm going to jump ahead for a second. There is a hearing.
Because on the two documents forms, one says affirmation certificate examining the physician, and on the other form it says same thing, or a licensed psychologist.
So it can be two medical.
Okay, so I can do a neurologist and,
It can be two medical as long as somebody's going to, yes, as long as somebody's going to fill it out to the extent that you don't need to bring a doctor to the hearing.
I got it.
Okay?
then does it have to be
But now to jump to your
notarized?
question for a second, it can't be two doctors in the same practice. So it can't be the
That
top
would
that
be a
your child sees.
pediatrician
Yeah.
and then a neurologist.
Yeah, but you can't be your pediatrician and your pediatrician's partner.
No.
Okay. With a
Does it have
licensed
to be
psychologist, it cannot be a school psychologist, because most of them are not, they're psychiatrists, not, they're not licensed psychiatrists, they're licensed psychologists. Okay, so most of their schools do not have licensed psychiatrists, which is the MT. That's the distinction. So you can't usually get that form completed out of school.
Do those forms have to be notarized? The 2A does not show a notary like the other.
No, if the psychologist one is notarized, the other one's a doctor, we don't make them notarized. Anything else about doctors? Go ahead.
Yes, so I had an individual that, I was actually very excited to see from her notarized by a doctor. So eventually, get the form from the doctor, it's now over 6 months of the evaluation. It was a psychologist, so he said there's a.
So you can
certify.
So here's what happens a lot. So your child gets evaluated for services for OPWDD or for Social Security, and let's say you did that when they were 15 years old. Okay? And and now you're coming in and you want to do this when they're 17 and 18, and we say, this is 2 years old. If that same doctor recertify, so they'll sign and they'll recertify and say, I agree that everything I wrote in here 2 years ago is the same and there's been no changes. And they complete the form, then you don't have to have a whole new evaluation. It's going to be up to whether or not whether the doctor wants to do that. Some doctors,
Would they still need it for like 8-9 months?
no, you can
It's
have,
over 6 months by the 2-3
yeah, as long as
months.
it's within 6 months, it's fine.
Yeah.
So anything you hand into it has to be dated 6 months or, so if you were handing something in now, you couldn't be past August of 2025.
So if it was done June 2025,
No.
how long did the doctor, we have to do recertification?
Just ask, bring it back to the doctor's office and ask them if they can redate it for you. Or put a statement there that no circumstances have changed, or, over the past period that would warrant a correction in this form of report. You put the doctor initials in, puts their due date, and then
And that's it.
when I was going for coffee, working back to one concept, there are guardianship of the person in surrogate's court is specifically designated for a framework of individuals who have impairment on determining, the nature and consequences of their decision making. And there are specific diagnoses that the statute refers to. For example, autism, or neurological impairment that started prior to a certain age. People ask questions, well, what happens if, it's a parent is 75 years old and the child's 40-something years old, and the child has forms of emotional, mental illness. That doesn't fit into surrogate's court because it's not specifically designated. What happens if you want to limit guardianship? For example, the person is unfortunately addicted to drugs or alcohol. That does not fit in, although they may be impaired to a degree. Those are types of guardianship that we would refer you to the Supreme Court. It's in Article 81 where the judge could tailor. Okay, you can make decisions about A, B, and C, but as far as money is concerned, unfortunately, if you're using drugs or alcohol, we're going to hold your money in trust in a particular way. So there are tailored guardianships. That's not what we're talking about here. Unfortunately, the statute, which they're looking to change, is basically an all or nothing. So that's why the judge takes, when we ask for medical reports, the judge takes it very seriously because it's not something we could say, well, they could go out and do work and then, and maintain an account up to a certain amount of money. This would not fall into that category.
Most of the things I'm hitting on, I know I'm jumping around and not going over the forms with you, because I'm kind of telling you the law, what you need to know is what I'm trying to do instead. So for instance, that 6-month thing, that's not something that we've come up with, it's in the statute. These are things that we cannot take, which is why I'm jumping around as they come into my head that I see all the time, okay? So I don't know what to say now, okay.
I'm sorry.
No, that's okay. We talked about for a second, if you have a divorce and you have custody of your child. Also, not even trying to think of it, if you have an order from family court giving you guardianship, that also expires at the age of 18 years old, okay? If you've adopted a child out of foster care and you have a kinship foster care guardianship, also expires at the age of 18. So any other type of guardianship that you may have extinguishes at the age of 18 years old. Sometimes people are often confused about that. So it's completely separate, and you still need to come to surrogate's court if you require guardianship for a disabled person past the age of 18. The two other forms I want to touch on just very briefly and let you see are the consent, oath, and designation, and the waiver of process.
I'm sorry, just to interrupt you. Just can you repeat what you said, that the custody arrangement after 18 stopped and now this is now the new custody?
Well, it's not a custody, but it's a guardianship.
It's a guardianship.
It's a guardianship.
Whatever was decided prior to the 18th birthday is...
Yeah, because there's been no once you turn 18, the child then can live on their own, right? But if there's If a person can't do that, then you need an adjudication from a court to say, this 18-year-old can't join the Army right now. Or do whatever they wanted to do on their own behalf because they need the permission of a guardian. So once you pass that, the framework of being an infant, the state of New York says now you are a full-fledged adult. So if you get stitches or need stitches in a hospital and you're 19 and you're shaking your head and pulling away, technically the hospital doctor can't do it.
Maybe we'll talk on context. If the child wasn't disabled at the time of the custody agreement, and now the child is permanently disabled, and now he's 18, then what?
Then you're, depending on what the disability is, you're either with us or you're with us.
You're gonna need.
So the other two forms that are in here, the consent oath and designation and the waiver process. These forms often confuse people, not because the information in here is confusing, they're just never sure of who needs to sign them. So basically everybody's signing these forms. The guardians are signing these forms, the standby guardians are signing these forms. Any other adult siblings that the child has, who you're coming forward for, anybody else over the age of 18 does not need to live in your house. If it's a sibling, a brother or sister, they need to sign off on these forms and they need to be handed in, all notarized, okay? So if you have a child who doesn't live with you anymore, they're away at college, or they're just, they live in Brooklyn now, and I'm sure, like, moms, what we're going to do, we're going to probably fill out all the information and we're going to send it to them, right? So they just sign their name on it. Make sure you tell them, go into the bank and sign it in front of a notary. Everything that you're handing into us needs to be notarized, and everything needs to be the original form. All right? So again, it's just pedigree information that's in here. It's going to ask you, who's going to be the standby, who's going to be the guardians, basically. And it's just so that we know that the rest of your family knows and is consenting to that. Yes.
Would a birth mother have to sign off on that if she has not if she had been deemed incompetent, so the child is not in her care and custody under age 18?
That's probably an off question because there's a lot more facts that are going to play into that.
No problem.
So you can see me afterwards.
Sure.
Otherwise, I'm going to ask you a question. So see me afterwards on that.
No problem. Thank you.
But just generally, like, let's go back to the same thing. You're divorced and dad is in the wind. You need to try to find dad. You need to do what's known as due diligence. Last known address, mail him the waiver. If you can't get in touch with him, if you don't know where he is, then you really need to call us and we'll tell you what you need to do, because we can't just say, oh, we don't know where dad is, because maybe dad lives around the corner, you just don't want to know where dad is, like the situation of the law, okay?
So I just want to clarify, so the waiver process is just for anyone who's over 18, related to the person, right, who does not want to be guardian or standby?
It's for anyone, if you're going to be a standby,
Then you wouldn't do
yeah,
this.
basically you want everybody to sign that. If you have everybody who's connected to you, including the guardians, the co-guardians, the standby, siblings over the age of 18 sign these two forms, you can't go wrong. These two forms are what we get most that are lacking, that we have to keep, that, Alex and Ron have to tell their staff, go back and, find, we're missing 3 signatures, 3 people didn't sign. This is what's usually missing the most, okay? So you can't go wrong by having actual people sign this form. We'll just keep it in the file. If you're missing the signatures, then we come back to you, okay? All right. I think I've kind of covered what I wanted to hit that I most often see now. I don't know if you want to take questions, or actually, I'm going to bring Alex up. Alex works she's right underneath Ron. I know everybody's disappointed that the judge is not here, but you really have the big shot who controls the record room. He's his staff who the paperwork goes through. Alex now got promoted, so she's definitely underneath him. They see all the paperwork before it gets to myself and Paul. We are in the legal department. You will only see us, you will only see us when all this paperwork is complete, or if you come in with some sort of complex file that they'll bring upstairs to us at this point. One other thing that I did forget, once all the paperwork is complete and it's done, what happens at that point? The paperwork comes to the legal department. Typically myself and another gentleman, not usually Paul, will hold a hearing. We have to legally have a hearing. It's not like you see on TV, which may or may not. Some people I think are disappointed in it because there's no adversary usually to these hearings. Who needs to be present for the hearing? It's going to be whoever the guardians are. So if it's yourself and a spouse, so mom and dad usually do not need the standby guardians, do not need to be there. But we mandate that the child be there. For the most part, we're doing them on Zoom, on Microsoft Teams rather, so that it keeps the child child in a comfortable surrounding in their home, in their school, in their group home for the most part. And it's basically a promotionary hearing at that point for most people, okay? Because by then we've read the files, we've read the doctor's information that's in there. And we're just going to ask you some basic questions that we need to get on the record. Via Microsoft Teams. Okay.
Yeah, and one thing, in the packet, you'll see a citation, and we'll assist you with the filling of that out. And the citation will direct you to serve your child. You can say, why is, I don't understand that, because the child wouldn't understand. Well, that's actually why we're doing it. It's a rarity, but we've had cases where the child reads it and says, wait a minute, I'm going to appear in this matter and strongly object that I have a guardian for me. So, again, the rights of every individual in the state of New York have to be protected. So they have this service of citation to make your child know that there's going to be a short hearing. They are going to be, during the Zoom, we want to see the child, and they will be present, so we want to make sure they're fully aware of the results that may occur in the event a guardianship is issued.
So yeah, we are going to attempt to, even if your child's not verbal, we are going to attempt to have a conversation with them. And this goes back to what Ron says, because unfortunately we have people who want guardianship of their child for sometimes monetary reasons. Sometimes they think they're, in their child's best interest, they just think their child's not able to function, and they are. We've had people come in. We had one kid who's in medical school. We had another unfortunate situation where the parents had just locked the child in the room for 18 years, and 3-4 years later, now full functioning in school. So there is bad in the world, and we know that, and so that is part of the reason that we want to see your child, okay? So the hearing is going to consist of mainly the guardian of your child. We're going to ask for information. We're going to usually tell us what your normal day is like, so you can say what it is that you do with your child on an everyday basis. Nothing to stress out about. It's the best type of hearing you could be involved in as far as the litigious. Nobody usually is going against you. Now, having said that, sometimes there are siblings or parents who are fighting, and that's a whole different thing. We're not going to get into that. Usually at that point you have attorneys, so it's not, it's nothing you need to think about at this point. But we will walk you through the hearings. We will put all these documents need to be known as entered into evidence. We're going to walk you through that. Again, that wouldn't happen in a normal hearing, but it is uncontested. We're going to help you with that. We're going to put the medical records into evidence. In most hearings, you have to bring the doctors in to testify. The purpose of these medical records is we're obviating the need for you to bring the doctors in. We're relying on what they're saying here, which is why we rely so heavily on, and I'm saying make sure the paperwork is complete. If we can't take it, we won't take it. If it doesn't tell us what we need to know, we're not that, okay? Anything else? Alex going to say two words.
As far as the interaction.
Okay. One other thing that runs through my head about the citation, if you cannot find somebody, you're going to call us, and we're going to talk to you later on about a citation. Dad is in the wind, he's entitled to legal notice. Those are things that we would do as a citation, not something I'm going to go into now, because most people don't need to know about it. But if you're in a situation like that, you can't find a sibling, including your child's sibling, or somebody just won't sign the waiver, you're going to contact us, we're going to tell you your next steps of how you legally go about to do that, okay? All right, let's talk a lot. I hope it made sense. I know I jumped around, but I'm just trying to hit on what I know people always need to know. So now, is Alex.
I'm definitely going to be pretty brief, but again, my name is Alexandra Torres, and I was just promoted to the Deputy Chief Clerk recently. Prior to working in the court system, I was actually a case manager with the DAP Community Network, so this community is very, I recognized you earlier, hello. So this community is definitely, I'm very familiar with it, and it's very near and dear to my heart, and I look forward to assisting all of you as much as possible in my new role. So aside from the people that are here today, we also, as Ron mentioned, have a lot of court clerks. So once you fill out this paperwork, you can bring it down to the courthouse. A clerk there will review it with you if you'd like. When we open the satellite location, there will also be someone available to do that. You can submit it through the mail and someone will be in touch with you. Once it's actually submitted and you're assigned a file number, it will be assigned to one of those clerks, most likely the person who reviewed it with you initially when you came in, but potentially someone else. That person will basically be your point of contact. In case there's anything else you need to submit, if there's something that needs to be corrected, they will let you know about that. Everyone that we have at the courthouse is very helpful and, like Ron mentioned earlier, very passionate about what we do. So they always look to assist as much as they can, and they can, if something, again, like if the dates past the 6 months or something like that, they'll just let you know before it actually goes for final review and things like that. So there's always something to. So also, Angela just mentioned, there is a filing fee, it's $20. You can pay that at the time that your papers are actually processed and when you're issued a file number. I'm trying to think of anything else. It's very brief, like I said, but basically.
Now, years ago, we used to tell them, put one in your wallet, put one in the glove compartment. Now people just take a photograph of the authority on their phone, and it's a great way to have it with you all the time in the event you're traveling to Florida and someone gets sick or not feeling well, the hospital will recognize it and have it available. So, and don't feel bad about it. Even myself, I've been fingerprinted. I was fingerprinted 40 years ago when I first started as a court officer. And even now, I just said, gee, I got to go fingerprint. I hope they don't find anything. It really, unless you're like Bonnie and Clyde, basically the judge wants to give you this authority because there's nobody better than you to take care of your child. So it's really got to be a bad situation. So even if something comes up, don't worry. But we've seen a lot of situations that have come up, and I wouldn't focus on it too much.
And like Angela mentioned, it's the honesty. So it's
Honesty.
hiding it that's more concerning, not necessarily what might turn up. As long as you disclose them, there can be a conversation and things like that. So that's definitely important. Again, I know very brief, but just to drive home the point that clerks, aside from everyone here, there are clerks that can answer questions and things like that and help you navigate the process. Once you fill out this paperwork, we're not just going to throw you to the wolves and have you just figure it out on your own. There's people to assist you as much as we're legally allowed to. So there will always be someone there to assist you throughout the way. And I know it can seem very daunting, and I know as both Ron and Angela mentioned that there's a lot going on individually in your lives from the day-to-day, so we just want to make sure that this is as easy as possible for all of you and as least stressful as it can possibly be. And we've had a good experience doing it, so thank you.
Hi, good morning.
Good morning.
I don't love microphones, so I'm going to talk really loud. I've been fortunate to work with the surrogate in both the assembly and the court. So I worked with Judge DiStefano when he was an assembly member. The judge has always taken the biggest proponent from day one that you guys are not just file numbers. There are families, our friends that are on Staten Island. In fact, I bumped into two people here today that have known me since I was born, Pam Thatcher, and Miss Generose known me since junior high. I went to junior high with her daughter. Where I come in, where Angela and I run, and Alex work hand in hand, I help review the settlements that come in. So say a 9/11 settlement, or asbestos litigation, or a med mal, or someone was hit by a car, etc. So we make sure that if your child is someone who's a beneficiary of those funds, we make sure that those are properly allocated. So Ms. Conti mentioned guardianship of the property. So for instance, I had a case yesterday, and when I was doing the case, the people only had a guardian of the person. So I informed them before we put the funds into an S&T, they need to go back, and that's why Ms. Conti mentioned amending the papers. So I'll make sure that those funds are properly put into the guardianship department. And what we do is we appoint someone that's called a guardian ad litem. It's different than a guardian. That's a court-appointed attorney who reviews the settlement on behalf of your child to make sure that the settlement is a fair and accurate settlement. So that's a lot of what I do in a nutshell on that side. I also review judicial accountings. So if the ward was a grandchild or a child and someone inherited money, and that fiduciary now has a responsibility to pay that money over to that person. So we'll get what's called accountings, and they'll make sure that the numbers all check out and balance out. I also help out with adoptions. That's my favorite part of my day. So I'm here and I'm happy to be here and help and see everybody again.
We could turn our chairs toward the audience. If you have general questions, that's fine. Once they finish, if you have any questions for us off to the side, that'll be fine as well. Are there any general questions after the presentation? Yes.
In the interim, before guardianship is granted, do you suggest having a power of attorney and a healthcare proxy done for the individual?
Well, like I said, the power of attorney is really dependent upon the person giving the authority. So what you have to ask yourself, you know, when people say, as a person gets older, and let's say they have power of attorney, or they didn't have power of attorney. Let's say mom or dad is starting to get a little sketchy out there, and they, you know, what an attorney's going to do is have an interview with mom and dad to see if they have capacity. If they start to say that Herbert Hoover is the current president, and that you know the year is 1929, then you're going to say, you know, the attorney's going to say, I don't think this person could grant power of attorney. So it all depends on the capacity. If the person had the capacity 20 years ago, before they had, God forbid, Alzheimer's or dementia set in, and you did the power of attorney then, you're good. But you have to have capacity at the time you're granting it. So maybe you would go to an attorney if your child seemed borderline, and the child has to be over the age of 18, right? They have to be of the age of majority, and they have to be willing to consent. The child's saying, you know what, I really don't want to give you any authority, well then you can't force it. So then you have to look at other means. And as Angela said, there's the decision-making process, which is good, where a child and then a group of individuals in the family, it could be a pastor, it could be somebody in the school, you get together and it's almost like a child becomes a participant in making a decision about their future. That's the decision making.
If you're of the opinion that your child qualifies for power of attorney, then you probably don't need us. So you probably want to support a decision making for power of attorney right off the bat.
Like, this is my son, so we are going to go for the guardianship because he does need assistance and everything. But in the meantime, like you said, obviously helps the product.
So okay, I'm going to interrupt because what your question is, if your child, if somebody needs a guardianship here, they're not going to be able to decide a power of attorney. So if you take somebody into an attorney's office, like Ron said, they're going to ask basic questions. If the basic cognitive ability is not there, you're not going to get a power of attorney. But the power of attorney, you need to understand what you're giving to somebody.
Right.
So if you qualify for this type of guardianship, you wouldn't qualify for a power of attorney, and vice versa. Do you understand the distinction?
Okay. I was just wondering, you know, I mean, obviously there is knowledge, but I just want protection. But I guess the healthcare proxy would help in the meantime as well.
Yeah, those would definitely help, and
Right.
they kick in when the person, if the decision is beyond that individual.
Right, if they're
whether
in
it's
surgery or
capacity or an
something, yes.
illness,
Right.
you know, and as we get older, we should all think about that. For example,
Of course.
we went and we did our will, my wife, and how they usually do it at the time, they grant power of attorney, because right now I'm healthy and I understand what's going on, but what happens if I get too sick or weak? It kicks in then, you know, she's got to make a decision about my health or whatever. So I think it's an important concept for all of us to think about. Yes, sir.
So my question is actually for Jacqueline Tripodi. On the reimbursement, do you guys also reimburse the FSS for power of attorney or just for guardianship and special
There
needs?
is the special needs trust or any legal fees associated with obtaining guardianship. You do need to have OPWDD eligibility.
Right.
The individual does need to live at home with you. If you have self-direction, then what you need to do as part of your self-direction budget is allocate a direct provider purchase to be an FSS agency. I work for the New York State Institute on Disability. We have an FSS contract. Center for Family Support has something like that. ABSP, ADAPT, who am I missing? ABSP adapts and NICEAD. I work for NICEAD, just saying, throwing it out there. I'm here, just saying, throwing it out there. If you have questions, I'm more than happy to answer, but you do need to have that allocated within your budget. The maximum amount is $3,000, and it would be within the fiscal year. So if you went and you had it done on June 27th, we can't do it this fiscal year. Those funds are no longer available. So just keep that in mind, that whatever attorney fees that you have put in place, whether it be to establish a supplemental needs trust, special needs trust, or the legal fees to obtain guardianship, they need to be dated within the current fiscal year. Did you have anything else? I was pretty loud and pretty clear.
Is this the family reimbursement?
That is correct. It's family support services.
And if you have traditional services,
Right.
you don't have, you're eligible.
Right, it's right, but just, it's there. So anybody has any questions, I can give, my cell phone number is 929-202-1115. And my email is jtripodi, my first initial last name, @niceadinc.org.
And I'm just gonna kind of second, because I actually work as a broker, so I actually work with a couple of my clients now. It's been very smooth for them, they've gotten the money, which has been great. I'm not aware actually of anyone except for you guys that actually do the legal part, some of the other agencies who mentioned.
Well, they all do. All of the FSS agencies can do it.
Okay.
Yeah, all of them, so.
Get one of these family support brochures, this all 4 agencies that have
FSS. Yeah, I'll see
Any other questions? We're definitely gonna stay around. And again, I said, I'm in the work you guys do every day, whether it's to help in the disability community or you're a parent. Don't think that this is anything that's going to be difficult, because you're way beyond this capacity. You have the tenacity, you have the passion, you'll do it. It's just that we ask that, if you need correction, we'll make sure you know what to do. And sometimes when you come down, you'll get a little homework and you'll have to bring the paper back or mail it back to us. Or fortunately, if and when, God willing, we hope within the next 2 months to open a satellite, we will make sure we publicize that to the disability community as well as your local representatives and whatnot. So, and the bar associations will be aware. So we look forward to seeing you over there in the future.
Thank you. How about another round of applause? Special thank you, Ronald, Angela, Alex, Paul, just for all of these the presentations we do. This is one of the most interactive presentations that we offer, and I really give you a lot of credit for fielding all those questions. I don't even think we could do a formal QA because there's just too many for people to remember. In that moment, be able to provide and stop what you're doing and be so professional about it. Really wonderful. All of your efforts, your knowledge, and just the support you give the council and the family people with
There's my card here if anybody wants to call later, then I'm busy or next week.
Before we exit, I just have a couple brief announcements, and then the circuit court team is kind enough to stay by and answer some questions. I would like to call Diane Perugia. She just wants to give a very sort of important information.
Yes, before everybody leaves, it's very important. Kathy and I.
Just ask for another minute, guys, before I read up to announcements.
Kathy and I from Adult Services have arranged to have this talk. It's going to be on January 20th by Zoom. It is a talk on sexuality. We're calling it Bodies, Boundaries, and Relationships for People with Disabilities. Our speaker is Frank Cicero. He is a licensed psychologist, behavior analyst. I know he worked with Eden years ago. He's a great speaker. This is going to be fantastic. We didn't have an executive board meeting, so I couldn't get the word out. Brokers, tell your families, any DSPs, all people will benefit from this talk. And I really hope that we get the word out, because this will be a wonderful talk. Frank is doing this pro bono for us, so please, spread the word and attend this. We're going to try and get it copied as well. Thank you.
Thank you. We're going to skip committee reports, but we can do new business, old business as well. At the end, I see if there's two hands up, I have a couple other quick announcements. First, I'd like to welcome Cynthia. Cynthia, would you raise your hand? She's our new information coordinator for SIDDC. Wish you best of luck in your new role. I'd also just want to like to mention, on behalf of Advocacy Committee, they will be presenting in person in February's General Council meeting. But we do have the citywide legislative breakfast, which will be virtual, and that's scheduled for March 5th. More information to come. And we are very, March 6th, 7th, 6th, okay, thank you. And we're also very pleased to announce that we're going to have an in-person rally at CSI on February 27th. And there's more information to come. That's going to be, in addition, just more stronger advocacy efforts for our family members, self-advocates, providers, just to discuss anything budgetary concerns and concerns you have in the field. This is the time to do so. Also, if you are not a member of the council, we ask you to please join membership. We see a lot of new faces here. Please check out our website, and also you can check our website for information on meetings, and see what the council's up to, get committee updates. So again, we're going to skip committee updates for the interest of time, but I do want to just give another minute for any old business, new business. I see a couple hands. Jackie?
On the back, I also am with PS 37, District 75, they're having a mind and body wellness resource fair next Friday, the 23rd, from 10 to 12. We hope to have, we're going to have Metro Community Health Center, we're having CPU, we have Northwell, which we're very excited to have them there. The Jewish Board, anything that has to do with the health and mind wellness, it is open to the community. We encourage you to come. It's at 15 Fairfield Street. I had some flyers on the back. If you need to see me, I'm happy to share. 10 to 12 at PS 37R. We encourage you to come and get some resources and information to help your families. Some of those places might be individuals that do the evaluations, because we spoke about that. You don't know where to get them. Please come and see if we can get some information. So I just want to share that with you all.
Thanks, Jackie. That's right. Yes?
Hi, I'm Maggie from Scott University Hospital. In lieu of our Health and Clinical Services meeting in February, we're going to have a presenter February 4th at 11 a.m. Dr. Nona is going to do a presentation regarding treating patients with developmental disabilities and intellectual disabilities. More so, she's going to address any parent concerns regarding treatment for patients who come to the hospital or when you go see your provider. She would love to hear from parents and guardians regarding any concerns you may have if a patient comes to the hospital, and you have any thoughts or concerns about treatment by providers, medication reconciliation. So she would love to have the questions before so she can address them on the Zoom meeting that we're going to have. And she would love to hear from you, prior to the meeting, to address the questions, and if you don't think of any questions before it, you should attend the meeting, and hopefully she'll have time to address your questions or concerns at the end of the presentation. It will be at 11 a.m. I'll be sending flyers out. Health and Clinical Services Committee, Health and Clinical Services Committee, as well as the council. So look at the website.
How to go to the bathroom?
Look for an email.
I know where to go.
From the council. Thank you.
Thanks, Randy. Does anybody else have any new business or old business? Okay, so again, Okay, so again, I'm Jason Harlan, Chair of the SIDDC. On behalf of the SIDDC, we thank you very much.
for joining us today. Again, we thank the survey report team, and they're kind enough to stay to answer any further questions. But on behalf of all of us, we hope everyone has a wonderful weekend.